Good morning, everyone. This is the Vermont House Committee on Commerce and Economic Development. It is January 30th, 2025 at 11:02 in the morning. So we're back from a break. Now to have a walkthrough of H99, is an act relating to earned wage access services. So with us is Legislative Counsel Sagal, and Rick is going to walk us through this, and then Maria is actually going to take over the duties on H99. Rick, good morning. Thanks for joining us.
Morning, Rick Sagal, Office of Legislative Counsel. Are you all sick of me yet? This is no? Okay. It's the beginning. So H99 is a bill that would regulate earned wage access services in Vermont. And it's kind of as a backdrop before I share my screen. When I got the language for this, suggested language for this, I'd never heard of earned wage access services. So I don't know how many you have or haven't, but it might help kind of to understand what's going on here, what you're trying to regulate. So back where I come from in Texas, we have a lot of payday loan companies because they're not really regulated in Texas. In Vermont, they're quite regulated. In fact, I think it's almost impossible to operate a successful payday loan company in Vermont. So these companies, providers exist as kind of an in-between between these payday loan companies, which can have high interest rates, fees associated with those loans, and just getting your money directly from your employer. So how it works typically is usually you're an hourly employee and you work for a company either as an independent contractor or as an employee, and you can access your money that you've earned before your pay period. So most people are paid every 2 weeks in this country. In some places it's monthly, but typically every 2 weeks in this country. You would have to usually wait to get your paycheck until that 2 weeks, right? So these companies, usually it's an app or something that you can access where you can get your money before those 2 weeks. Money you've earned, if you've worked 2 days, you can get that 2 days of pay into your checking account. That's what this is. And employers offer this as a benefit to their employees. Like, hey, we have this benefit. You can get your money earlier than you normally would. And currently in Vermont, it's not regulated. So some states have started doing this. California and Connecticut have pretty stringent laws that treat these companies more like loan companies. Most other states are doing what this language suggests, which is regulating it, but also not treating them like a loan company. So there's kind of different ways of going here. This language, just to be fully disclosure here, is more of we're just going to regulate these as a business instead of a lender, which has much more stringent transparency requirements, those kind of things. Is that a good backdrop? Done.
So, yeah, just a little clarification. Payday lending is not illegal, but you need to become a licensed lender in the state of Vermont in order to provide those services, which they decline to do. This system is a little different, where they're advancing part of your wage to you and before you receive it. They're not charging you any interest. They're not charging you anything. It's a voluntary. If you want to provide if you want to provide some type of fee for what they've done, for what they're doing in assisting you getting your paycheck earlier, you can, but you don't have to. It's not a requirement. We looked at this bill. We looked at a similar bill a couple of years ago. There were some defaults in there of what you could, what their suggestions were, like say $2. More like like a tip thing. I think in this bill, you'll see that that's gone. So as we go through the bill, and we take testimony from the people that are advocates, which are generally the businesses that are providing these, we'll hear from them. We'll hear from others as well. So, but I just want to make sure that we're differentiating. So they're operating in the state of Vermont right now, unregulated. So this is a way of putting some regulation, making sure DFR is watching and making sure things they're supposed to do, they are doing.
Thank you, Mr. Chair. Yes. And like Mr. Chair said, Maria, my colleague, will be taking over because she's much more involved with DFR than I am and understands the regulatory portion of this. I understand the consumer protection portion of it. She does too. But I think this fits in more with her portfolio. But since I didn't draft this, I've used our style to come up with this bill. I'll kind of do the walkthrough and then she'll take over and probably answer questions better than I can, although I'll try my best to answer questions. Okay, so we start with definitions, which most bills, especially when you create a new chapter, which this bill does, has definitions. You're going to see that this definition come up on other bills as well, this biometric data. So just kind of be aware of what this is. This is data generated from the technological processing of an individual's unique biological, physical, or physiological characteristics that is linked or reasonably linkable to. And you have these things that are very much personal to us, your iris scan, your fingerprints, hand mapping, facial mapping, vein patterns, voice prints, gait, or personally identifying physical movement or patterns. Most importantly, it does not include a digital or physical photograph, audio or video recording, or any data generated from a digital or physical photograph or from an audio or video recording, unless that is generated to identify a specific individual. So why is this in this bill? Because eventually you'll see that this bill prevents these earned wage providers from selling this data for a profit. And you'll see it as it comes up. Consumer means an individual residing in the state. Direct-to-consumer provider means a provider that offers, and we'll define provider here in a little bit, means a provider that offers or provides earned wage access services directly to consumers based on their representations and the provider's reasonable determination of the consumer's earned but unpaid income. Earned but unpaid income is salary, wages, or other income that an obliger, typically an employer, owes but is not yet paid to a consumer. And that second half is not as important. Definition 5, earned wage access services means the business of delivering proceeds to consumers prior to the next date on which an obliger is obligated to pay salary, wages, compensation, or other income. Employee integrated provider means a provider that offers or provides earned wage access services to a consumer using time and attendance or earnings data for the relevant pay period that is provided directly or indirectly by an obliger. A licensee is a provider who has been issued a license pursuant to this chapter. An obliger, again, typically employer, means a person. And I'm going to stop here at person for a second, since a lot of you are new to Vermont law. So person, unless it's defined otherwise, means almost any kind of entity. It means, yes, individuals. It also means corporations, partnerships, sole proprietorships, unincorporated entities, the state, local municipalities. So it includes a huge net of entities. It's going to kind of sound confusing sometimes when I refer to something as a person being a corporation or a state government, but it does. Okay, so a person who is legally obligated to pay salary, wages, compensation, or other income for work that a consumer performs on an hourly, project-based, piecework, or other basis. Outstanding proceeds means proceeds transferred to consumer by a provider and not yet repaid to the provider. Another kind of techie definition, precise geolocation data means information derived from technology that can precisely and accurately identify the specific location of a consumer within a radius of 1,850 feet. Why that specific number? I don't know, but that is the number that we have landed on, not just me, but in general, that's the amount of feet that is determined to be precise. But we all know our phones are more precise than that, right? Precise geolocation data does not include the content of communications, data generated by or connected to an advanced utility metering infrastructure system, or data generated by equipment used by a utility company. We're almost done with definitions. Proceeds means an amount of funds a provider transfers to a consumer that is based on earned but unpaid income. And finally, a provider means a person who is in the business of offering and providing earned wage access services to consumers. Okay, now it's what the bill is actually requiring. A person shall not provide an earned wage access service in the state without first obtaining a license pursuant to this chapter. Subsection B, a person, including a provider's financial institution, typically a bank, and I would let Maria discuss an interbank clearinghouse, what that is and what that means. But the crux of subsection B is that if a bank or similar institution becomes aware that a earned wage access provider is not licensed, this institution shall not provide, quote, substantial assistance to a provider. Substantial assistance is not defined in this act. My assumption is this means that the bank would not work with the provider, that would be a block to conduct a business if they were not licensed, but might not hurt to ask from other experts the intent there. And here the standard is if you know or consciously avoid knowing if a bank decides to kind of head their head in the sand and work with these earned wage providers that are not licensed, they would be in violation of subsection B. Subsection C1, subsection A, meaning the requiring to be licensed, does not apply to a financial institution, again, banks, if the institution is authorized by law to accept deposits and the deposits are federally insured. Not my area of expertise, but that's a pretty big exemption, right? To certain institutions that do not have to get licensed to do this service. However, if you don't have to obtain a license, pursuant to that previous paragraph, you still have to comply with the chapter. So you may not have to be licensed and pay the fee and be regulated by the Department of Financial Regulations, but you still have to apply or comply with the provisions of this chapter. Okay, section 2303, application for a license. This just gives a list of things that the provider must supply when it's requesting a license. And Mr. Chair, I can read through these or the committee can look at them. They're just, a description of what you do, whether you're employer integrated or if you're direct consumer or both, a list of states that you provide the service in, description of the amount of fees that you charge, if you have any bankruptcy or receivership proceedings affecting your business, and any other information required by the commissioner. So this is kind of important here, right? That the commissioner can be more specific than you're being here with the legislation. This is pretty common because you can't spell out everything that the commissioner may think is in the best interest. So this gives that position the authority to add other requirements of the licensee. 2304. So once you become a licensee, these are your requirements in Vermont if you were to pass as written. Basic services. A licensee shall make available to each consumer a basic level of service that provides a reasonable option to receive proceeds at no cost to the consumer. I do want to highlight there's going to be other options where you may have fees as a consumer if you choose those options. Again, I've never used the service. I'm not sure what other services there would be. However, there must be a reasonable option to not have a fee when you use the service. I think the chair was talking about that. Okay, subsection B, a licensee that is an employer integrated provider may impose a fee or charge on an obliger who contracts with licensee in order to, so here are kind of some, not exceptions, but this is what licensees can do when it comes to fees. You can charge the obliger to offer the service to their employees. So you're not charging the employee, you're charging the employer. Or B, provide additional services to consumers who are employees or contractors of the obligor. Subdivision 2, subject to the requirements set forth in a future section, I'll get to. A licensee may offer additional services that may be subject to the following charges or fees. So this is giving the providers, licensees now, ways to charge not employers necessarily, although I think it might need to be spelled out here. Are these charges or fees to employers, or are they to obligers, or are they to consumers? I think they're to both, but it's not explicitly written here. A charge or fee for the optional expedited delivery. That makes it clear it's for consumers, right? Or B, a subscription or membership fee for a bona fide group of services that includes earned wage access services. What is a bona fide group of services? Again, I don't know. I'll let the people that do this tell you what that is. I don't know what that would be. Any questions about that? The no cost versus there's this optional thing you could sign up for. Okay.
Would the bona fide group of additional services also be regulated by DFR? Or are we only regulating the earned wage access?
I think the way I need to double check, but my understanding is that there would be some kind of check, especially in rulemaking authority, that the commissioner could say, as in statute, we're going to tell you what's bona fide, what's not bona fide. But I want to double check, make sure that's clear.
Do you want us to save questions or go through as we go to? I can wait.
I think it's easier to go through questions as we go along.
Okay.
Instead of just make sure the questions are more operational.
Right.
And then, we'll have all the other people in this afternoon.
Yeah. And so I'm just curious, we have basic services and it's for free. To the consumer.
Mhm.
How do they get paid then? How does the service provider get paid for those services? I mean, they get it on their business, so how do they, is it because of the tie-in to employer services?
That's probably more
I can't figure out.
For later.
For the people that are providing the services.
Yeah, no problem.
I had the same question.
Questions now about.
Yes.
Oh, okay.
I, just to go back to the banking exception, so I understand it. So financial institutions that are receiving deposits that are federally insured would be exempt from overseeing these EWA organization.
I think they're exempt from the license requirement.
From so the bank itself would not have to get an additional license.
Correct.
They still have to supervise and be aware of it. Yep.
All of their banking is up
Yep.
to snuff, but, okay, gotcha, thank you.
Yep. Okay, subsection C, optional gratuity. A licensee may solicit an optional gratuity from the consumer before finalizing the payment of proceeds, provided that the licensee complies with subdivision 2306. We're going to get there in a second. The licensee provides clear notice that a gratuity is optional. The licensee provides the consumer a clear and accessible option to leave no gratuity And 4, to approve a gratuity, the consumer must affirmatively consent to contributing the gratuity after entering a dollar amount or percentage value.
Kirk has a question.
So the way I read that is, employer providers, I mean, they can be charged a fee by whatever it is, the provider can charge the employer if they're going that way. Direct to service, they don't charge a fee like that. But the optional gratuity, either type of provider could ask for a gratuity.
That's correct.
Okay.
So the employer has a service to their employees, can pay for the service. But they can also ask the employee to provide a gratuity as well.
So this might be a question for,
But I mean, the way it's written right now.
yes.
Okay.
Yes, I frankly don't know technically how the employer provided works. If they still contract with a third party, I'm guessing they do, but I don't know. Okay, subsection D, required disclosures. Before providing a consumer with earned wage access services, a licensee shall provide the consumer with written or electronic notice of the terms and conditions, which the licensee may include as part of the service contract. The notice shall use language intended to be easily understood by a layperson. State that the commissioner has jurisdiction over the earned wage access services. Provide a phone number and website for complaints. State that the basic earned wage access services are available at no cost, and specify the type and amount of charges and fees the licensee may impose for additional earned wage access services. Subsection or subdivision 2, anytime a licensee offers or provides an additional earned wage access service, or it imposes a charge or fee, the licensee shall comply with any disclosure requirements and standards the commissioner adopts by rule or order. A licensee shall clearly show the unique identifier issued to it by the nationwide multi-state licensing system and registry on its internet website, on all solicitations and advertisements directed to consumers, and on any other documents as the commissioner requires by rule or order. Okay, subsection E, cancellation of service. A licensee that offers or provides earned wage access services on a recurring basis or as part of a subscription service shall allow a consumer to cancel participation in the service at any time without a cancellation fee. Termination. If authorized by the licensee and consumer in their service contract, a licensee may terminate service to a consumer who does not repay outstanding proceeds or pay a charge or fee permitted by law. Reporting. You'll see this a lot in especially this is a new type of service. So the subsection G requires that the commissioner ask for each licensee to submit an annual report that includes a summary of what it's done the previous year, calendar year. And then the commissioner collates those reports and comes to this committee and the Senate committee that kind of gives a summary of what's going on. So you all also aware of how the service is working.
If I opt to leave gratuity and I only have 50 cents in my account and it bounces because I left a dollar, is that an outstanding shop fee? So we were, it was just in the previous section that we had
Yep.
just for the, is, the termination of service.
Right here.
Yeah, is that a gratuity feels different from a charge or fee, but if I indicate that I want to leave it and somehow I'm not good for it, can I be terminated for that?
I would probably let the Your specific question, I think, yes. However, I don't know how that gratuity system works, if it's taking a percentage of your proceeds just out. If, let's say you request $100.
Yep.
And you give $1 of that as gratuity. You would not have to repay that. You'd have to repay the $99 of the 100, right?
Everything's on the back end.
Yeah.
So if
Okay.
you request $100, you're gonna get $100. And when you get paid, when your paycheck hits your bank account, then they're going to withdraw the 100. You have to authorize that to happen. At the same time, that's when you decide whether you want to give them gratuity or not. So I think, but I think what would happen if you're gonna overdraw your account if you don't have the funds that are in there, which means you're gonna get nailed by the bank.
And there's language addressing that coming up. Yeah. The gratuity thing threw me off. Gratuity, I don't know how that, it's a good question. Maybe better for someone else who knows how the actual money is transferred.
We'll get into it.
Thanks a lot.
Yeah. Okay, 2305, non-recourse, which, is a fancy way of saying collateral is not required. They can't come back to your collateral. I'll just explain the language here. Except as otherwise provided in subsection B of this section, a licensee shall provide earned wage access services on a non-recourse basis and shall not attempt to collect payment of outstanding proceeds, charges, or fees through any means, including in a civil action or proceeding in any court, through arbitration or other alternative dispute resolution process, or through any third-party actor. A licensee may collect repayment of outstanding proceeds, charges, or fees only as follows. 1, payroll deduction. Pursuant to the written agreements with the consumer and the obligor, a licensee that is an employee integrated provider may initiate an obligor-facilitated payroll deduction, a direct payment to the provider by or on behalf of the obligor, or an obligor-facilitated assignment of the outstanding proceeds from the consumer's next paycheck following the day proceeds were paid. B, a licensee may not make more than 4 total attempts at a payroll deduction, direct payment, or assignment pursuant to subdivision A of the subdivision. Meaning this one here. 2, electronic transfer. A licensee may make as many as 4 attempts at electronic transfer of funds from a consumer's depository account at a financial institution if the consumer consents to the repayment of outstanding proceeds, charges, or fees through electronic transfer. The licensee provides prior notice of the date and the amount of the transfer. The licensee attempts a transfer only on the date and the amount specified in the notice. The licensee complies with all requirements applicable to the payment system it uses to make an electronic transfer, including any applicable National Automated Clearinghouse Association rules. And the licensee uses reasonable care to avoid causing the consumer to incur a fee or penalty for insufficient funds. A licensee who violates one of those items I just went over shall reimburse a consumer for any fee or penalty the consumer incurs due to the violation. Periodic invoice. A licensee may submit not more than 3 periodic written invoices to a consumer for payment. Other means. A licensee may use other means of collection that the commissioner approves by rule or order. 5, misrepresentation and fraud. A licensee may collect outstanding proceeds, charges, fees, and any other amounts available by law if a consumer provides false information in the course of procuring earned wage access services or received proceeds with the intent to defraud the provider. I'm just thinking if 5 is in conflict with A. Okay, it's except it's provided subdivision B. Okay. 2306, prohibited acts and practices. A licensee shall not, one, impose or attempt to collect a charge, fee, penalty, or interest for basic earned wage acts and services under subsection 2304A. That's the basic services, the free option. B, for employer services or additional services, if not otherwise authorized under subsection 2304B. Just going back to show you what that is. That's these additional services. That includes the bona fide group of services for membership, those kind of things. C, for failure to pay, repay outstanding proceeds or to pay any fee or charge. Or to defer the collection of outstanding proceeds beyond the original schedule for collection. Okay, we're still under a licensee shall not. So subdivision 2, a licensee shall not present fees authorized under subsection 2304B, again, those additional services, or voluntary gratuities authorized under subsection 2304C as default options. So think about when you are setting this up, you would have to choose to do the additional service. The basic service should be the default option selected on your phone or on your computer when you're signing up. 3, condition the availability of terms of earned wage acts and services, including the amount of proceeds and the frequency of payments on A, whether the consumer chooses optional additional services, the amount or type of charges or fees the consumer agrees to pay. C, a requirement that the consumer transfer ownership or control of or create a security interest in the consumer's property as security for the repayment of outstanding proceeds. Or D, a consumer's credit report or credit score. They shall not sell, offer for sale, lease, share, or trade in exchange for anything of value, the biometric data, there it is, or precise geolocation data of a consumer to that consumer's obligor or to any person other than the consumer's obligor without having first obtained the affirmative consent of the consumer. We don't have this defined, so this could just be a checkbox. This could be easier maybe than you think to consent to. I have my data privacy mind, right? Think about how that might work, just so you all know. If you want to be more specific, then you might want to define what that is. Subdivision 5, commit an unfair or deceptive act in commerce pursuant to the Consumer Protection Act of Vermont, including A, making a false or deceptive statement or representation, or a fraudulent misrepresentation to a consumer, the commissioner, or a government agency, soliciting a consumer to delay repayment of outstanding proceeds for the purpose of increasing the total charges or fees the licensee may collect, and C, any act, practice, or conduct prohibited in connection with the collection of or attempt to collect a debt arising out of consumer transaction under the Consumer Protection Act or any rule adopted by the Attorney General under that subsection.
Great. So this, the way this is written then would, they would be regulated by Department of Financial Regulation under all of their penalties that they provide. And also the Attorney General then could also go after them under the Consumer Protection.
Correct. So we're still on the shall nots. A licensee shall not report a consumer's payment or failed repayment of proceeds or payment of any fee or charge to a consumer reporting agency or debt collector. Shall not discriminate against a consumer based on the basis of sex, marital status, race, color, origin. It goes on, provided that a licensee is not required to do business with a consumer that lacks legal capacity to contract due to the consumer's disability or minor age, So that's to protect a licensee in case a minor, when they enter into a contract, a minor doesn't necessarily have to live up to their end of the contract because they don't have the capacity as a minor to enter into a contract. So this is just language protecting the licensee from giving money to a minor and the minor never reimbursing the licensee because they don't actually have a contract with the minor. Does that make sense? Shall not transfer proceeds to a consumer in a virtual currency or in an instrument denominated in virtual currency without the prior approval, this is crypto, without the prior approval of the commissioner in a writing expressly referencing the subdivision other than a virtual currency issued or insured by the United States or its agency or instrumentality. That's a Maria question in case you have questions about. Does the US even have crypto that's been issued or insured by the US?
Not yet.
Yeah.
There's been a lot of talk about it.
Okay, 2307. These are also going to be a bit above my head, but I'll read them to you. The provision of earned wage access service by licensee in accordance with this chapter is not a loan, subject to Chapter 73 of this title, a wage assignment under Section 2234 or 2235, a money transmission. So basically, I think what we're doing here is ensuring that it's fairly clear what this is regulating, but this is just making sure that this language does not apply to unintended other maybe similar types of business arrangements. So this is just about earned wage access services, not about a loan, not about a wage assignment. The rules, 2308. The commissioner may adopt rules and orders and issue specific rulings, demands, and findings as are necessary for the administration and the enforcement of this chapter and for the protection of consumers who obtained earned wage access services in the state, including imposing limits and requirements on the amount, type, and disclosure regarding earned wage access services and charges or fees for services.
This may be a federal versus state kind of issue, but at the federal level, there has been changes in interpretation of West Municipal for agency rules. Cut back on the ability of federal agencies to write rules within the expertise of that agency. Now, this is state level. Is there anything to be concerned about in terms of this rule or in terms of that kind of development? You know, obviously state is state and federal is federal.
Yeah.
Any concern there around specificity of what can be done?
So if the federal government, there have been laws introduced in Congress to regulate earned wage access services. None have passed, obviously. If that were to happen, you could have some preemption, meaning the federal law would take over the state law, would make this paragraph not important anyway. But, you know, if that were to happen and this law were to be more protective of consumers than the federal law, whatever it was going to be, you may be able to say that this Vermont is going to abide by federal law, yes, but also our law is more protective, and therefore it's not preempted by the federal law. So in that case, the rulemaking could be important, and comparing it to the federal rulemaking, I think it's fairly clear that it's talking about our state law specific to earned wage accesses in the state. If you want to mention federal rulemaking, we could maybe, think about what that would look like.
I'm not going there, just, curious about, what going forward and the Chevron decision. And of course, that's federal, but, just trying to get a sense of whether we should be concerned about that sort of trend in federal law as it might apply to state law.
That's a good question. Yeah, I appreciate it. I think most of our rules are written this way, not really explicitly calling out the feds, but it might be something to consider going forward is, if the feds were to do something, how do we separate the rulemaking authority?
I mean, this is probably not specific to this, but
Yeah.
what you said before is if we are more protective, then it's okay. And if we are allowing for rules that could be looked at as more protective, right? So again, not an argument for today, we're not, but there probably is an argument that could be made that we can still have rulemaking,
Yeah.
right?
It's just-
So I'll contradict myself a little bit, which I shouldn't be doing. It's not always, so just because we're more protected does not mean we would survive a preemption. If the federal law explicitly says we are controlling all earned wage access in the country, Vermont's law would be preempted, but that's rarely done. But a law that regulates this would be presumably better for every state to have the same regulation, right? So they may want to say that for ease of compliance, every state should have the same earned wage access system. So I just want to make sure that it's not always going to be protective, meaning less preemption. Yeah.
I think if they did that, then they should be the ones providing the rules and regulations,
Right, they would be. Yeah.
statute for it.
Yeah, this law would be ineffective. Then we have the Private Right of Action, Consumer Protection Act, which clarifies that a consumer may bring a private right of action for damages caused by a violation of this chapter against a provider that was required to be licensed but was not. So think about that. This is specific to a provider that did not get licensed when they should have been licensed. It's not that they did something else that violated the law, that they didn't have a default option checked or something. This is specific to you did this, you conducted this business, work with consumers without being licensed, and therefore consumers have the right to hold you accountable for that. Subsection B, the powers vested in the commissioner by this chapter shall be in addition to any other powers or rights of consumers or the attorney general or others under any applicable law, including the Vermont Consumer Protection Act and any applicable rules adopted under the act, provided that the commissioner's determinations concerning the interpretation and administration of the provisions of this chapter and any rules adopted under this chapter shall carry a presumption of validity. Pretty standard language about rulemaking. Okay, the rest of the bill is partly cleanup and also partly addressing the fees to become a licensee. 2102. Again, this was suggested language, and Mr. Chair, I would run this by DFR because this would apply to all applicants for licenses in this specific section, not just to earned wage access providers. There might be a reason that this language was suggested. And my guess is that at some point, Vermont changed or categorized limited liability companies, partnerships as associations. You could lump them all. I don't know. I didn't have time to look that up. That's my guess.
We'll have
Yeah.
to actually maybe have a talk with David Hall.
Yeah.
Secretary of State's office, to make sure that this is the correct language.
Yes, it's not a huge change, but it is something to know what you're doing. And then you have subdivision 15, which lists all the fees under these applications, and we're adding 15, which says for an application for an earned wage access provider, $1,000 is a license fee and $1,000 as an application and investigation fee.
This will send this off to Ways and Means when pass it out of here, because it is a fee and Ways and Means, that's their purview.
What is an investigation fee? Is that a whenever it occurs, or is that an annual?
I think it's So BFR would do an investigation on the company. So it's an application invested. So they're gonna pay $1,000 for the license, gonna pay $1,000 for the application and investigation that goes along with it.
It's the create.
Covering the costs of DFR's time. Whether or not that's the right fee or not, I don't know, but ways and means are waiting for that.
My question is, where did those numbers come from?
So if you want to compare, if you look up Section 8, I'm sorry, Title 8, VSA 2102, you can see how much the other applications cost. I think the language is pretty similar across each one. 2109, annual renewal of license. So we're just adding subdivision 15 for an earned wage access service provider. It is $1,200 per year to maintain that license. Renewal fee. In
We specify somewhere and this is the term of the license, just is it an annual renewal for the $1,200 or is it a 5-year thing and they have to keep?
so I'm sorry, I skipped past it. This is already in law, right? So
Okay.
it says, and these are for every annual renewal that applies in this section. This 2109, again, this is not my typical area of law, so there's probably several different types of entities that have to do these licenses, not just earned wage, but several other types of businesses. And it is always for the next succeeding calendar year and shall pay whatever the fee is. In this case, for the earned wage provider, the suggestion is $1,200 per year. Okay. Okay, section 4, and now we're amending the definition of financial institution, which that definition was earlier in the bill. It includes a credit union, a financial institution subsidiary, licensed lender, mortgage broker, and we're adding earned wage access service provider as a financial institution. Again, this could have collateral effects. I don't know. This is something you want to ask about and see what that means.
Sure, we'll hear from our
Yeah.
bankers association.
Yeah. And then finally, you have the implementation grace period. So the license requirement set forth that early in the bill begins on January 1st, 2026. Notwithstanding, which that word, you're gonna see that from time to time. So ignoring subsection a person providing earned wage access services in the state as of January 1st, 2025 may continue providing earned wage access services without a license through December 31st, 2025, or until the license is denied. If 1, the provider submits an application for a license before January 1st, 2026, and the provider otherwise complies with APSA Chapter 75, which I believe regulates financial institutions, but subsection C, solely for purposes of APSA 2309A, a provider that has complied with subsection B of the section shall be deemed to be a licensee during the grace period provided by subsection B of the section. Let me go back up, show you what we're talking about here. Too far. So going back to the private right of action, if a licensee or if a provider does not get licensed, remember, they can be held accountable by the consumer. So if they've complied with this, if they've actually requested a license during the grace period, they shall be deemed to have been in compliance. So they can't be sued by a consumer yet, is what this is saying. Okay. And the act takes effect July 1st, 2025, but again, everything's kind of a year out. to ensure there's time for compliance and making sure your company gets licensed and all that stuff.
Is it when the provider submits an application before January 1st? Is they'd be able on December 30th to submit an application, they'd be able to operate without that application being reviewed on January 1st, 2026?
So if they filed on December 31st, 2025, you're asking, would they be able to operate as a licensee, quote unquote,
Right.
until they hear
Mhm.
about their, yes. So basically, and they would not be subject to being sued as a non-licensee.
Is that the standard operating procedure for when that applications can be submitted up to the day before the license requirement, begins?
So I can't speak to that standard. You could set an earlier date if you think that there should be this built-in period of time. Maybe it's October, maybe it's, I don't know how long it takes to handle these applications. But yeah, that's something you could write in is force a bigger period of time in between.
But I should make sure that I am understanding
Mhm.
the language, as the language is written, that scenario is plausible. A December 30th application for a license and a January 1st or 2nd, sort of, I guess, activity beginning.
Yeah, so if you apply before January 1st, which in your case, right, the last possible day, which never happens. I'm joking. December 31st, 2025, if that were to happen, that provider would be immune from being held as an unlicensed provider until they are either denied a license, or if they don't comply for some reason, if they violate something else in a VSA Chapter 75. And yes, so there is, I don't know how long it would take for that application to be reviewed, but that's something.
For the private right of action.
Right.
They're still accountable to DFR and accountable to the Attorney General's office.
Right. Just as far as consumers suing because you're acting unlicensed, that would not be available to them. Yeah.
Anything else, Rick?
So I have a question, which is about the definition of earned but unpaid income.
Okay.
And that is the chunk of money that goes to a whole variety of things like taxes and you know what I mean? Like if you have earned $100, but you're really only going to get 80. Like, should it be in statute that you can't request more? You can't request money that you've earned that is actually going to, you know what I mean? So should it,
I think we're gonna hear more from the industry
okay,
on,
so that's more of an,
yeah, because, say you're in $500 a week,
yeah,
you're not going to be able to access it.
Okay.
So I think we'll hear more about that.
okay,
But keep that question though, because
Yeah.
that may be something that we may want to put in there depending on what the answer is here for that
Okay.
question. Yeah, question.
I just want to highlight this bill and the difference between our last bill, right? Our last bill was a 7-month process with legislative counsel and internal folks in the state working on the bill. This is a bill that comes to us from industry based on things that are happening in other states. So we have different kind of work, different kind of lens to look at when we look at this.
But to go along with that, industry has brought this stuff, so they want to be licensed in the state, provide their services for the people that we're going to hear from today. Maybe not be all earned wage access businesses that are out there. I don't know how many there are, but the ones that we'll hear from are bringing this to us and asking to be regulated, licensed in the state. Okay, there's no other questions. I think we'll break for lunch and back here, promptly at 1, we have a long list of people that want to chat with us about this. So we